Oops, oopsie doos. Let's see here. Hopefully this is going to work. Okay. Hello. Good morning, everybody. I have comments turned off. We're going old school for a little bit this morning. Hello. Hello, Kaya. Good to see you. So I've turned off comments, everybody, because I have a case here that I would like to go through for a little bit. I will do a Q&A after I have finished reading, but I really wanted to keep my attention on this case. Sometimes when I'm doing comments, I get distracted easily. So I'll just go through and read some of the most important pieces of this case. And I thought this judge out of Maryland did an amazing job going through the history of birthright citizenship and the history in this country, going through all the precedents, cases out of 1800. So she just did an amazing job on this order. So I thought, well, let's look through it. There's some really important stuff in here. So double checking. So let's go ahead and get started. And again, at the end, I will turn on comments. We can do a Q&A in here for everyone who may have some questions. So this case or this opinion was issued yesterday. This is the case number. We've got the birthright citizenship situation involving an executive order from Mr. Trump. And of course, there's a lot of questions about that because of the Constitution. So this is one of two. The other case that had an injunction is the state of Washington. So if you're interested in looking up the other case, this is the case number here. This is that temporary restraining order, again, out of Washington. But yesterday we had a preliminary injunction done, and this was out of Maryland. So here's the case number if you're interested, and up here, and then we also have this filing number as well. This is a civil action, so we're in civil court in Maryland. Now, I know a lot of people have questions on birthright citizenship, and, I understand. So I thought this case and her decision here is really helpful to understand kind of what's going on. So I'll go ahead and read through some of this, and then I will open the floor up for questions after I have finished here for a little bit. So welcome on in, everyone. Here we go. We've got, it was filed yesterday. Here's the case number. This is document 65 on the docket. And this is a memorandum opinion by the judge there in Maryland. So let's take a look real quick and see who we have. We have Judge Boardman, U.S. District Judge, again in Maryland. So let's go ahead and get started. In 1868, yep, we're going back, everybody. In 1868, the United States Congress ratified the 14th Amendment to the United States Constitution. The Citizenship Clause of the 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And then we are citing the 14th Amendment, Section 1, Clause 1. More than 150 years after the 14th Amendment was ratified, the newly sworn-in President of the United States, Donald J. Trump, signed an executive order called Protecting the Meaning and Value of American Citizenship. Now, his executive orders, everyone, are now in the Federal Register, so you can pull them up online, and there are numbers that has just been going on in the last few days. So those are up to date. The executive order interprets the Citizenship Clause of the 14th Amendment in a manner that the Supreme Court has resoundingly rejected, and no court in the country has ever endorsed. If the order is allowed to take effect, it would deny citizenship by birth to U.S.-born persons whose mothers are in the country unlawfully or temporarily, and whose fathers are not citizens or lawful permanent residents at the time of the person's birth. The day after the executive order was issued, CASA Inc., an asylum seeker advocacy project 2 nonprofit organizations that provide services to immigrants, and 5 pregnant women without permanent legal status who expect to give birth in the United States in the coming months filed this lawsuit against President Trump. The Secretary of the U.S. Department of State, the U.S. Attorney General, the Secretary of the U.S. Department of Homeland Security, the Director of U.S. Citizenship and Immigration Services, the Commissioner of the Social Security Administration in the United States of America. So, as a party here in this suit, the plaintiffs allege that the executive order violates the 14th Amendment to the Constitution and the Immigration and Nationality Act. They request a preliminary injunction that enjoins implementation and enforcement of the executive order until the merits of their claim are resolved. The government opposes preliminary injunctive relief. The plaintiffs easily have met the standard for a preliminary injunction. There is a very strong likelihood of success on the merits. The plaintiffs will face irreparable harm without injunctive relief, and the balance of the equities and public interests strongly weigh in favor of a preliminary injunction. The motion for a preliminary injunction is granted, so we see that's the final answer here. The defendants are enjoined from implementing and enforcing the executive order. So right off the bat, everybody, we have that granting of the preliminary injunction. Here's our background. At noon on January 20th, President Trump took the oath of office of the President of the United States. Later that day, President Trump signed an executive order called Protecting the Meaning and Value of American Citizenship. The executive order purports to interpret the clause subject to the jurisdiction thereof in the Citizenship Clause of the 14th Amendment. In Section 1 of the order, titled Purpose, the order explains that the 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Executive Order Section 1 continues. And so here's our executive order that she is citing. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of the United States citizenship does not automatically extend to persons born in the United States. 1, when the person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. Or 2, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as but not limited to visiting the United States under the auspices of the Visa Waiver Program or visiting on a student, work, or tourist visa. So it doesn't matter if you have a visa or you don't have a visa. Everyone is included here in this executive order. And the father was not a United States citizen or lawful permanent resident at the time of said person's birth. Section 2 of the order establishes the policy of the United States government. Under Section 2, no federal department or agency shall issue documents recognizing United States citizenship or accept documents issued by state, local, or other governments or authorities purporting to recognize United States citizenship to a person whose mother was unlawfully present or lawfully present with only temporary status and whose father was neither a United States citizen nor lawful permanent resident at the time of that person's birth. The policy applies only to persons who are born in the United States on or after February 19th of 2025. It does not impact the ability of other people, including children of lawful permanent residents, to get documentation of their American citizenship. So this executive order is actually quite a bit broader than how it has been portrayed. Section 3 of the order discusses enforcement. It instructs the Secretary of State, the Attorney General, the Secretary of Homeland Security, and the Commissioner of Social Security to, quote, take all appropriate measures to ensure that the regulation and policies of their respective departments and agencies are consistent with this order. and that their agencies, officers, employees, and agents act in accordance with this order. It also instructs the heads of executive departments and agencies to issue public guidance regarding their implementation of the order within 30 days of its issuance. On January 21st of 2025, the plaintiffs filed this lawsuit against President Trump, the Secretary of the U.S. Department of State, the U.S. Attorney General, the Secretary of the U.S. Department of Homeland Security, the Director of U.S. Citizenship and Immigration Services, the Commissioner of the Social Security Administration, and the United States of America. Each individual defendant is sued in their official capacity. The plaintiffs claim that the executive order violates the 14th Amendment and the Immigration and Nationality Act. They seek declaratory and injunctive relief. The two organizational plaintiffs are CASA, an asylum seeker advocacy project, ASAP. CASA is a nonprofit organization headquartered in Prince George County in Maryland. It is the largest membership-based immigrant rights organization in the Mid-Atlantic region with more than 175,000 members. Its mission is to create a more just society by building power and improving the quality of life in working-class Black Latinos or Latinas, Afro-descendant, Indigenous, and immigrant communities. It helps members apply for public benefits and offers free legal consultation. CASA does not issue formal membership to anyone under the age of 15, though it does provide services to young people and their families. CASA's members include women without lawful status who are pregnant or plan to give birth in the United States. Under the order, their children born in the United States would no longer be U.S. citizens. ASAP is a nonprofit organization headquartered in New York, New York. It is the largest membership-based organization of asylum seekers in the United States with over 680,000 members from more than 175 countries who reside in all 50 states and several U.S. territories. ASAP's mission is to help its members, individuals seeking asylum, to build a more welcoming United States. To that end, it provides members with community and legal support. ASAP does not extend formal membership to people under the age of 14, but the benefits of ASAP membership may extend to them through their parents' membership. Just a little background on a couple of the parties that actually brought the suit here. Most ASAP members have applied for asylum and cannot be deported while their asylum applications are pending. ASAP expects that hundreds or even thousands of its members will give birth to children in the United States over the coming weeks and months. Despite being born in the United States, those children would not be U.S. citizens under this order. The individual plaintiffs, Maribel, Juana, Trinidad, Garcia, Monica, and Liza, are proceeding under pseudonyms. And we have footnote number 1. The individual plaintiffs have asked to proceed under pseudonyms because they fear that the U.S. government and members of the public could retaliate against them or their minor children because of their participation in this lawsuit. The government does not oppose the motion, provided the plaintiffs provide the identities of those individuals on request, if necessary, to permit it to fully defend this case. The motion to proceed under pseudonyms is granted. If the government needs to know the identities of the individual plaintiffs to defend this case, it may file a request for relief from the court. And so far as I've looked through the docket, they have not filed that request as of this live here. Maribel is a member of CASA. She's undocumented, lives in the United States for 18 years. She's pregnant and due in July of 2025. Juana is a CASA member. She has a pending asylum claim. She's 2 months pregnant. Trinidad Garcia is a member of ASAP. She and her partner came to the United States on tourist visas in 2017 and filed affirmative asylum applications. They are awaiting their asylum interview. Trinidad Garcia is pregnant and due August of 2025. She and her partner are citizens of Venezuela. Venezuela does not provide consular services in the United States, so she fears that her child would be rendered stateless by the order. Monica is also an ASAP member from Venezuela. She has temporary protected status and has filed an application for asylum. She is pregnant and due in August of 2025. Like Trinidad Garcia, she fears that her child would be rendered stateless by the order. Liza is married to an ASAP member who's seeking asylum. Liza is currently in lawful status on a student visa. She is pregnant and due May of 2025. She and her husband are Russian citizens who fear persecution from the Russian government. They are afraid to apply for Russian citizenship for their child and are worried their child will be rendered stateless by the order. We have footnote number 2 here. Unless otherwise noted, the plaintiffs refer to the individual plaintiffs and members of the organizational plaintiffs who are pregnant. The plaintiffs filed a motion for a temporary restraining order and preliminary injunction. The government opposed the preliminary injunction. The plaintiffs filed a reply. 3 amici filed briefs, and those are friends of the court, so extra information. A group of local governments and local government officials, the Immigration Reform Law Institute, and the state of Tennessee. The court heard argument on the motion on February 5th, which was yesterday. Here's our discussion. The plaintiffs seek preliminary injunction that enjoins the implementation and enforcement of the executive order. The government argues that the plaintiffs do not have a cause of action and that preliminary injunctive relief is unwarranted. The court finds that the plaintiffs do have a cause of action and that the preliminary injunctive relief is warranted. Reviewability of executive order. Now, I'll just kind of start and go through some of this, but I want to make sure that we get into the analysis the court uses under the ARC case, which a lot of people have been hearing about. So we'll kind of skip through some of this. As a threshold matter, the court must decide if plaintiff's constitutional claim is subject to judicial review. So this is the history. Are we allowed to even look at executive orders? So we're citing case law here stating before the court turns to the merit, it must decide whether plaintiff's claims are reviewable. And then down here we have footnote number 3. The court need not decide whether it may review the plaintiff's statutory claim because the plaintiffs are entitled to a preliminary injunction on their constitutional claim. The claims are essentially coterminous because the statute mirrors the Citizenship Clause. Although the court has a duty to avoid deciding constitutional questions presented unless essential to proper disposition of the case. And they're citing case law stating the constitutional question presented here is essential to the proper disposition of the issues before the court. So the court's saying, we've got a constitutional question, so yeah, it's okay to bring this to court. The plaintiffs claim the executive order violates the 14th Amendment Citizenship Clause. There is no question that the court may review the constitutionality of the executive order and grant injunctive relief. The Supreme Court consistently has sustained that the jurisdiction of the federal courts is to issue injunctions to protect rights safeguarded by the Constitution. And we're citing case law here to support that. One more piece here, the injunctive relief has long been recognized as the proper means for preventing entities from acting unconstitutionally. And I just want to highlight that, everyone. We have lots and lots of people, lots of questions saying, who's going to stop Mr. Trump? Who's going to stop the executive branch? And just a friendly reminder, well, it's supposed to be the courts, right? It's supposed to be this injunctive relief, which is supposed to call out whomever is acting unconstitutionally. The Supreme Court has affirmed that the president's actions may be reviewed for constitutionality, and it is well established that review of the legality of presidential actions can ordinarily be obtained in a suit seeking to enjoin the officers who attempt to enforce the president's directive. And then further case law here. And we've got a quote, an independent claim of a president's violation of the Constitution would certainly be reviewable. We've got another case here. The Supreme Court explained that the ability to sue to enjoin unconstitutional actions by state and federal officers is the creation of courts of equity and reflects a long history of judicial review of illegal executive action tracing back to England. Next, pursuant to this authority, the Supreme Court has reviewed constitutional challenges to executive orders. And then they're citing some of our biggest cases. Probably the biggest case, if you're interested, is going to be this Youngstown Sheet and Tube Company versus Sawyer. This is one of the most landmark cases we have on presidential power, where the president had issued an executive order to take over the steel working world here because the workers were headed out to strike. And so, they're like, hey, you can't do that because we're right in the middle of this situation with Korea. And the executive order was deemed unconstitutional because it exceeded the president's authority. During President Trump's first term, the Supreme Court decided a constitutional challenge to one of his proclamations, and this is the Trump v. Hawaii case. And this case had to do with the original travel ban, where they came back and did an analysis, but by the time they made their decision, Trump was no longer in office. So they said, well, here's our analysis, but in reality, we don't really need to give you a decision on it because it's moot. The government insists the plaintiffs have an available and exclusive mechanism to challenge disputes about citizenship under the INA. According to the government, the plaintiffs must pursue their claims through a declaratory action under 8 United States Code Section 1503A of the INA. Section 1503A allows any person who is within the United States and who claims a right or privilege as a national of the United States and is denied such right or privilege by any department or independent agency or official thereof upon the ground that he is not a national of the United States to seek declaratory relief after the final administration denial of such right or privilege. And they're reciting the U.S. Code here. The INA provision does not prevent the plaintiffs from bringing a facial constitutional challenge to the executive order. The text of the INA does not indicate that Section 1503A is the exclusive remedy for challenging the denial of a right to citizenship under the 14th Amendment. The Supreme Court has cautioned against reading a statutory right to judicial review as an exclusive route to review when the text neither expressly nor implicitly limits the court's jurisdiction. And citing U.S. Supreme Court case here out of 2010, which states a statute permitting judicial review of the Securities and Exchange Commission's rules and orders was not the exclusive route to review constitutional claims against a government board subject to the commission's good cause removal power. And then we're quoting another case out of 2023 that was decided by this current U.S. Supreme Court, concluding federal statutes allowing courts of appeal to review an agency order did not displace district court jurisdiction over far-reaching constitutional claims. Indeed, judicial review under the INA is not the exclusive mechanism to challenge policies that deny citizenship, citing case law here. Further, the plaintiffs cannot pursue their constitutional challenge to the executive order. The statute provides a cause of action to any person who is within the United States who claims a right or privilege as a national of the United States. The plaintiffs are not seeking a judgment declaring their children to be nationals of the United States after the denial of a particular right or privilege, such as the denial of a passport. Citing further case law here and here. Instead, the plaintiffs seek immediate injunction relief from the executive order because the order is facially unconstitutional and denies citizenship to their unborn children. So the government is incorrect. So that's a pretty important piece here. That distinction the judge is making here. Section 1503A of the INA does not offer the plaintiffs an exclusive and available remedy for their constitutional challenge to the executive order. The plaintiffs can seek protection from unconstitutional executive action in this court. As the Supreme Court has explained, quote, the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury, in the right of every individual to claim the protection of the laws whenever he receives an injury, to sustain the jurisdiction of the federal courts to issue injunctions to protect rights, safeguard safeguarded by the Constitution and to restrain individual state officers from doing what the 14th Amendment forbids the states to do. That's pretty powerful language, and we're citing this out of the Davis case in 1979, and they're quoting Marbury versus Madison, which of course is one of the most important cases, the case that established judicial review. The court can review the plaintiff's claim that this executive order violates the 14th Amendment. So again, I think it's important everyone to kind of walk through this history here, procedural history, because we're going to be seeing it over and over and over again. When people are challenging executive orders, we're going to repeatedly see this analysis because you can file that an executive order is unconstitutional. And this is the precedent that allows for that. Section B, motion for preliminary injunction. To obtain a preliminary injunction, the plaintiffs must establish 4 factors. 1, that they are likely to succeed on the merits. 2, that they are likely to suffer irreparable harm if preliminary relief is not granted. 3, that the balance of equities favors them. And 4, that an injunction is in the public interest. And these 4 pieces are in the Frazier case and multiple other cases. So it looks like they're citing Frazier, which is citing the Winter case here out of 2008. Plaintiffs must satisfy all 4 factors in order to obtain the preliminary injunction here. Our preliminary injunction is an extraordinary remedy that may only be awarded upon a clear showing that the plaintiff is entitled to such relief. The plaintiffs have shown they are entitled to this extraordinary remedy. So this is the part where I'm going to kind of skip through just a little bit here because I want to get to the constitutional law analysis here that the judge is giving. So first, she goes through the likelihood of success and deems that there is a very high likelihood of success here, pulling in case law from 1888, from all of our other prior cases. This is 1866 case, 1804 case, 1832 case, 1806. Now, these cases, you may think, well, they're super old, but right now we've got a history and tradition issue going on with our U.S. Supreme Court. So the more cases that you can get from the 1800s, the better to show that we've got precedent to support it. And in fact, going through their analysis here, we even have the Dred Scott case cited, which is arguably one of the worst cases ever decided by the U.S. Supreme Court. So again, I'm just kind of skipping through this just a little bit so we can get to the further analysis down here. So let me just take a peek. I should have paged this out before I hopped on, but I didn't. So there we go. And I just want to make sure. Okay, we'll go over to the slaughterhouse cases. So if you are interested, this is a 32-page order. You can go back and look at those few pages that I've kind of skipped through here if you are interested. But for the interest of time here, I do want to start going through the ARC case. So here we go. We'll pick back up here on page 20. So right now, again, the court's going through this analysis of whether or not they would succeed on the merits, all right? So likelihood of success is our number that we're going through. And then we're going to pick up halfway through their analysis under the ARC analysis, all right? So let's go to the government's arguments. The government argues under Wong Kim ARC. That, again, is the case that established birthright citizenship under the 14th Amendment, under the clause. A person's parents must, at the time of person's birth, be lawfully domiciled in the country for the person to be subject to the jurisdiction. The government insists that the ARC case imposes a parental domicile requirement for citizenship under the 14th Amendment because the court mentioned, quote, domicile or domiciled throughout the opinion. True, the court included in the question presented at the beginning of the opinion and in the answer at the end of the opinion that Wong Kim Ark's parents at the time of his birth had a permanent domicile and residence in the United States. Also true, the court stated, quote, the amendment in clear words and in manifest intent includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. However, the fact that Wong Kim Ark's parents were domiciled and resided in the United States was not essential to the holding or the outcome. And even though the court described the parents of children born within the territory of the United States as domiciled within the United States, the word domicile does not appear in the text of the 14th Amendment. And English common law did not impose parental domicile requirements. In fact, under English common law and the decisions of the United States courts that followed it, the right of citizenship by birth included children of non-citizens' parents not domiciled in the country. So again, we're quoting the Wong Kim Ark case. Now, for anyone that is unfamiliar with the Wong Kim Ark case, this is a case where there were two parents from China originally that lived in the United States. They had Mr. Wong Kim Ark while they lived here. They went back to China. He went with them. And then when he came back, they didn't let him enter the country because we had the Chinese Exclusion Act, which was a terribly racist piece of law that did exactly what it stated at the title. But he said, well, look, dudes, I grew up in the U.S., so I'm a U.S. citizen. I was born here. And they said, no, I don't think so. And so it went all the way up to the U.S. Supreme Court. And the U.S. Supreme Court was like, 14th Amendment, yes. Now, unfortunately for Mr. Wong Kim Ark, he spent a lot of time in a boat in the harbor waiting to actually be able to literally put his feet on land in the U.S. And by the time the decision came down, he had had about enough of it and went back to China. So he did not get to enjoy the privileges of citizenship, but his was the case that established that 14th Amendment piece, just as a little history. So we're citing Wong Kim Ark again, noting the English common law rule that every person born within the dominions of the crown was an English subject, no matter whether the English or a foreign parents, if they were English or foreign parents, and in the latter case, whether the parents were settled or merely temporarily sojourning in the country. And then we have another case here, 1608. Local obedience being but momentary and uncertain is yet strong enough to make a natural subject, for if he hath issue here, that issue is a natural born subject. Next up, we have a case out of 1844, applying English common law and holding plaintiff was an American citizen because she was born in the United States, even though her parents were only temporarily sojourning in the United States when she was born. These cases are part of the common law that the 14th Amendment affirmed. Again, this judge here is going through the history and tradition, right? So if this goes all the way up to the U.S. Supreme Court, this judge has set it all out. You want your history and tradition? Well, here it is. To be a person born in the United States and subject to the jurisdiction thereof does not require the person's parents to be domiciled in the United States at the time of birth. And then we have footnote 4 here. The government cites Benny v. O'Brien, which suggested that the 14th Amendment exempted from citizenship those born in the country of foreign parents who are temporarily traveling here, and children born of persons resident here in the diplomatic service of foreign governments. Benny, a decision from an intermediate New Jersey court that came down before Wong Kim Ark, has no precedential value. So the judge is saying, this case actually doesn't apply here, so I'm tossing it. Next, the government argues that under Wong Kim Ark, a person born in the United States is subject to the jurisdiction of the United States only if he's born in the allegiance and under the protection of this country. And his allegiance is unqualified by allegiance to any alien power. Now we're quoting another case. This is the Elk case here. The government misconstrues the language of Wong Kim Ark. As the court explained, quote, the fundamental principle of the common law with regard to English nationality was birth within allegiance, also called legality, obedience, faith, or power of the king. The principle embraced all persons born within the king's allegiance. Put differently, all persons born in the allegiance of the king are natural born subjects, and all persons born in allegiance of the United States are natural born citizens. Quoting the Rhodes case. That is to say, every man born within the jurisdiction is a subject of the sovereign of the country where he is born. And then we're quoting the Killam case. Quote, allegiance is not personal to the sovereign in the extent that it has been contended for. It is due to him in his political capacity of sovereign of the territory where the person owing the allegiance was born. At common law, the only people born within the kingdom without allegiance to the king were children of diplomatic representatives or hostile occupiers. That is because they were not entitled to the king's protection under common law. Children of diplomatic representatives were born under the actual protection of the dominions of a foreign prince. And they were quoting an 1830 case here. Children of hostile occupiers certainly were not entitled to any protection of the sovereign. All this to say, again, I think our judge is really writing out an amazing background piece here, everyone. So all of this to say, if a person is born in the United States and does not belong to one of the traditional classes of accepted persons, the person is born within the allegiance of the United States and subject to the jurisdiction of the United States. Wong Kim Ark did not hold, as the government maintains, that a person born in the United States is only subject to the jurisdiction of the United States if the person bears exclusive allegiance to the United States at the time of birth. Contrary to the government's position, Wong Kim Ark did not interpret subject to jurisdiction thereof in the Citizenship Clause of the 14th Amendment to exclude persons born in the United States whose parents are not domiciled in the United States or persons who hold allegiance to another country. So, of course, this is one of the biggest arguments. You'll see this in the Washington case, too, right, where we had our first injunction was out of Washington, and you'll see it over and over and over again, this argument that the government's making regarding a subject to the jurisdiction of and whether or not domicile is a piece of that. The executive order directly conflicts with Wong Kim Ark. Under Wong Kim Ark, a person born in the United States and subject to the jurisdiction thereof encompasses every person born in this country, save specific classes of people. The executive order purports to expand the classes of people that are not subject to the jurisdiction thereof, and thus to deny citizenship by birth to people who are entitled to it under the Constitution. The children targeted by the executive order do not fit within any of the limited exceptions to citizenship by birth identified in Wong Kim Ark. They are not children of ambassadors, children of enemies in the country during a hostile occupation, children born of foreign seas, or children born into Indian tribes. Of course, we're using this language. That's how the language is set out in the law. For what she is quoting here. So here's footnote number 5 that gives us a little bit more detail here. On the same day, the president issued the executive order at issue here. He issued another executive order that describes, quote, an unprecedented flood of illegal immigration, end quote, in which, quote, millions of illegal aliens who present significant threats to national security and public safety have entered the country illegally. And then she's citing his executive order. In its briefing, the government suggests that a broad inclusive reading of the Citizenship clauses subject of jurisdiction thereof will result in citizenship by birth to children of individuals who present such threats, including even unlawful enemy combatants who enter this country in an effort to create sleeper cells or other hostile threats. The government seems to advocate for a broader reading of one of the exceptions to the citizenship by birth, children born of alien enemies and hostile occupation, to include the children described in the executive order. The meaning of the clause subject to the jurisdiction thereof was explained clearly in Wong Kim Ark. It is meant to be expansive. The exception for children born of alien enemies in hostile occupation applies during a hostile occupation of part of the king's dominions. A hostile occupation entails the firm possession of a territory territory that enables the occupier to exercise the fullest rights of the sovereignty over that place. And then we're citing an 1819 case. This exception to citizenship by birth plainly does not apply to the children described in the executive order. There are children whose citizenship by birth has been recognized in this country since the ratification of the 14th Amendment. When the children described in the executive order are born, they will be citizens, United States citizens under the 14th Amendment, and long-standing Supreme Court precedent. The president does not have the authority to strip them of their constitutional right to citizenship by birth. So right here, we're getting into a balance of powers issue. And that's one of the big issues that the Supreme Court has been talking about over the last few years when it comes to who does what. Specifically with the 14th Amendment in the Griswold case or the Anderson case out of Colorado, separation of powers, right? Balance of powers. The government cites no case decided after Wong Kim Ark that supports the president's interpretation of the 14th Amendment. And there is none. And they're not doing that because there aren't any. Instead, the government relies principally on two cases decided before Wong Kim Ark. For some reason, I cannot get his name out, everyone. I apologize. So Elk v. Wilkins, 1884, and the slaughterhouse cases of 1872. Now, I have done a post on the slaughterhouse cases, so if you do a search and my name, you should be able to pull up some of the posts that I've done on these cases. I've not done one on the Elk case, but if you're interested in the history of those cases, you can take a peek. Elk and the slaughterhouse cases are no help to the government, which I agree. I don't know why slaughterhouse was even brought up, but whatever. Wong Kim Ark discussed both cases at length and distinguished them. It found that Elk's interpretation of subject to the jurisdiction thereof did not apply outside the context of Indian tribes, because Elk concerned only members of the Indian tribes within the United States and had no tendency to deny citizenship to children born in the United States of foreign parents of Caucasian, African, or Mongolian descent, not in the diplomatic service of a foreign country. Thus, Elk's holding is confined to members of Indian tribes. The children identified in the executive order are not akin to members of Indian tribes who in the 19th century enjoyed a unique political status and quasi-sovereignty. So if you are interested, several people have been asking me about our Indigenous peoples' citizenship. I would highly recommend pulling this case here, Elk v. Wilkins. It was out of 1884, and that gives you a little bit of history there. Now, footnote number 6 notes that Congress gave members of Indian tribes citizenships by birth in 1924, and this is the federal statute that establishes that. So it's 8 United States Code section 1401, subsection B. So this is where our Indigenous people have been granted citizenship. We've got a quote here. It would be obviously inconsistent with the semi-independent character of such a tribe and with the obedience they are expected to render to their tribal head that they should be vested with the complete rights or, on the other, subjected to a full responsibilities of American citizens. Elk does not apply to this case, nor do the slaughterhouse cases. The government relies on the following language from the slaughterhouse cases. The phrase, subject to its jurisdiction, was intended to exclude from its operation children of ministers, consuls, and citizens of subjects of foreign nations born within the United States. The government argues subjects of foreign states includes children described in the executive order. The problem for the government is that Wong Kim Ark repudiated this language from the slaughterhouse cases because it was wholly aside from the question in judgment and from the course of reasoning bearing upon the case, and it was unsupported by any argument or by any reference to authorities. And then we have footnote 7 here that says, again, I'm going into this because I think this is really important history for everyone to remember when you're working with this birthright citizenship issue. The only other cases the government says support its position that parental domicile is necessary to be subject to the jurisdiction of the United States are Chinbak Khan v. U.S. 1902 and Kwak John Fat in 1920. The Chinbak Khan, the court stated the ruling in Wong Kim Ark and included the fact that Wong Kim Ark's parents had a permanent domicile and residence in the United States. And so we're quoting that. In Kwak John Fat, the petitioner claimed to be a U.S. citizen by birth, but the government investigation concluded that he was actually born in China and entered the United States as a minor. The parties did not dispute that if the petitioner's parents were who he said they were, he would have been born to them when they were permanently domiciled in the United States and would be a United States citizen. Both cases reference Wong Kim Ark only in passing. Neither case held that a person's parents must be domiciled in the United States for their U.S.-born children to be subject to the jurisdiction of the United States. All right, so they're still fighting this domicile issue here by pulling these other cases. The government has not identified any case that supports the president's interpretation of the 14th Amendment. And that, I was going to say that's one of the key pieces here when we're looking into a lot of the issues that are going to be raised by these executive orders, and there are going to be a ton of cases. There are going to be some significant issues actually finding any precedent supporting the government stance because there aren't any. In the 125 years since Wong Kim Ark, the Supreme Court has never questioned whether a child born in the United States whose parents did not have lawful status or were in the country temporarily was an American citizen. We've got a cite here of the Shogunesi case. The petitioners who were married to each other worked as crew members on foreign ships that came into port in the United States. They entered the United States lawfully and remained in the country after their 29-day visas expired. The wife gave birth 3 months after her permission to stay expired and 2 months after her husband's permission to stay expired. Half the year later, deportation proceedings were instituted against both parents, and they asked to suspend deportation on the ground of the economic detriment that would befall their minor son in the event that they were deported. The court remarked that their child was, of course, an American citizen by birth. We have Justice Douglas dissenting. The citizen is a 5-year-old boy who was born here and who therefore is entitled to all the rights, privileges, and immunities which the 14th Amendment bestows on every citizen. And then we're citing multiple cases here as well. The Supreme Court considered 2 appeals of deportation orders. Both petitioners entered the United States by making fraudulent misrepresentations to immigration officers, and after entry, each had a child in the United States. Even though the children's parents had procured entry into the country by fraud, the court did not question that the children were American citizens by virtue of their birth in the United States. Again, there's just case after case after case supporting this. And so they're pulling out another case, stating first, petitioner's child acquired United States citizenship at birth, and second, petitioner's child became an American citizen at birth. And in Hampty Rumsfeld, the Supreme Court considered the legality of the government's detention of the United States citizen on United States soil as an enemy combatant. That was in 2004. An amicus brief urged the court to find the enemy combatant was not a citizen because his parents were in the United States on temporary visas when he was born. And that again is an amicus case here. So citing that case again, despite that urging, the court recognized that the person detained was an American citizen because he was born in the United States. In other cases, the Supreme Court never has intimated that the immigration status of the parents might affect whether the U.S.-born children are citizens at birth. 1985 case, noting that the undocumented respondent who had entered the country without permission had given birth to a child who, born in the United States, was a citizen of this country. And then we're citing Vance. Applee was born in this country, the son of a Mexican citizen. He thus acquired at birth for both United States and Mexican citizenship. We are just about done. Only a couple more pages here, everyone, and then I will do a Q&A session. And this one is citing the Rogers case out of 1971, acknowledging that American citizenship law follows English concepts with an acceptance of the jus soli. And then they're citing another Dulles case. This isn't Trope v. Dulles. This is a different Dulles case out of 1958. Petitioner was born in Artesia, California in 1916 by reason of the fact that he was a citizen of the United States, and because of the citizenship of his parents, he was also considered by Japan to be a citizen of that country. And then I'll pause here just to state that in Project 2025, they're stating they do not want to have any kind of dual citizenship go forward. So you cannot have two levels of citizenship, just an FYI. In the Kawakita case, noting the petitioner was born in the United States to Japanese citizen parents and was thus a citizen of the United States by birth. Now, this next case, everybody, oh my goodness gracious. So it's Hirabayashi. This is, oh my gosh, this case drives me bonkers. This is a terrible, terrible, terrible case decided by the U.S. Supreme Court. It is still good law, but is an absolute atrocity, in my opinion. Probably one of the top 5 worst cases ever decided by the U.S. Supreme Court. And I'm not going to go into too much detail, but if you are interested in another case that the U.S. Supreme Court absolutely screwed up, there you have it in the Hirabayashi case, confirming that people of Japanese descent were citizens because they were born in the United States. There's probably the only few words in that entire case that are worth mentioning. Perkins, in 1939, cited Wong Kim Ark and finding that the plaintiff was still an American citizen because of her birth in the United States, even though she had moved abroad as a minor and acquired Swedish citizenship. And then another case here, a person of Japanese race is a citizen of the United States if he was born within the United States. Again, these are just case after case after case, everybody, that precedent being set out here by the judge. So I'll skip through this just a little bit further. The government's only response to these Supreme Court cases: it's not unusual for the Supreme Court, after fully exploring a legal issue, to reach a conclusion that conflicts with earlier assumptions. That is no response at all, although it's a very similar to some of the language that we've seen from Justice Thomas. The executive order flouts the plain language of the 14th Amendment to the United States Constitution, conflicts with binding Supreme Court precedent, and runs counter to the nation's 250-year history of citizenship by birth. The plaintiffs have shown an extremely strong likelihood they will succeed on the merits of their constitutional claim. So again, it's so important to set out case after case after case here with the precedent, right? So all the way going back to 1806, and then all the way up to 2023. Just case after case after case here. So last piece here is the irreparable harm. So the judge is going to go into what would happen if this executive order was put into place. Citizenship is a most precious right expressly guaranteed by the 14th Amendment to the Constitution. And we are citing a Kennedy case out of 1963 and a Perez case out of 1958 with Chief Justice Warren. Citizenship is a man's basic right, for it is nothing less than the right to have rights. The right to American citizenship is a right no less precious than life or liberty. Quoting the Clapret case, the deprivation of a constitutional right for even minimal periods of time unquestionably constitutes irreparable injury. And we have multiple string cites here because there's a likely constitutional violation. The irreparable harm factor is satisfied. And one more quote, the denial of a constitutional right constitutes irreparable harm for purposes of equitable jurisdiction. So again, you have to remember, you've got to show that there'd be some irreparable harm in order to go forward on the preliminary injunction, right? That's one of the four pieces required. And so they're saying here, because it involves a constitutional right, and that's just a fundamental piece in and of itself, that sets out that irreparable harm piece that's required. Here, the plaintiffs have established a strong likelihood of success of the merits on their claim that the executive order violates the 14th Amendment. The denial of the precious right to citizenship for any period of time will cause them irreparable harm. The government argues that any harm is speculative because the plaintiff's children will have other routes of obtaining status, such as seeking asylum. This argument is callous and wrong. The irreparable harm to the plaintiffs and their unborn children is concrete and imminent. If the court does not enjoin enforcement of the executive order, children born in the United States who are subject to the order immediately will be denied the benefits and rights of U.S. citizenship. The benefits of citizenship include access to certain government public benefit programs, such as health care through the Children's Health Insurance Program and food assistance through the Supplemental Nutrition Assistance Program. The rights of citizenship include the right to live in the United States lawfully and without fear of deportation. Without an injunction, all U.S.-born children subject to the executive order will have no legal status in this country when they are born. Without legal status at birth, children could be placed in removal proceedings and deported. Many of the plaintiffs have pending asylum applications or temporary legal status and are not subject to removal. If the order goes into effect, their children will be without legal status and may be subject to removal even if they are not. The order may cause some plaintiffs to be separated from their children. Citing 2019 case, finding plaintiffs would be irreparably harmed if deported and separated from his wife and children in the United States. Additionally, some children of the plaintiffs will be stateless if the order goes into effect. Statement of plaintiff Liza that her child would be stateless without American citizenship, as she and her husband cannot safely apply for Russian citizenship for their child. Statement of plaintiff Monica that her child would be stateless without American citizenship because there is no Venezuela consulate in the United States where she could apply for her child's Venezuelan citizenship. For stateless newborns, their very existence will be at the sufferance of the country in which they happen to find themselves. And this is quoting Trope v. Dulles, which is an incredibly important case, again, where we have someone whose citizenship was removed as a punishment. This had to do with a soldier stationed in Casablanca. He went over the wall and was like, I'm out of here. Well, they brought him back and he was court-martialed. And part of his punishment was that his citizenship was removed. That didn't really matter until 10 years later when he tried to get a passport. And that's went all the way up to the U.S. Supreme Court. And they said, you cannot remove somebody's citizenship. That would be cruel and unusual punishment. Without an injunction, the plaintiffs will face instability and uncertainty about the citizenship status of their newborn babies, and their children born on U.S. soil will be denied the rights and benefits of U.S. citizenship. The executive order, if not enjoined, will cause the plaintiffs and their children grave irreparable harm. So here's factor number 3. So again, we've only got one more page here. Balance of equities and public interest. The final two factors are balance of the equities and the public interest. The balance of the equities and the public interest merge when the government is the opposing party. To balance the equities, the court considers the relative harms to the applicant and respondent, as well as the interests of the public at large. And this is their string cites, just setting out those two pieces of the test here. The equities and the public interest weigh very strongly in the plaintiff's favor. Today, virtually every baby born on U.S. soil is a U.S. citizen upon birth. That is the law and tradition of our country. That law and tradition will remain the status quo pending the resolution of this case. The government will not be harmed if enforcement of the executive order is enjoined. Quote, a state is in no way harmed by issuance of a preliminary injunction which prevents the state from enforcing restrictions likely to be found unconstitutional. If anything, the system is improved by such an injunction. So she's justifying here the different levels of harm. And upholding constitutional rights surely serves the public interest. Upholding constitutional rights is in the public interest. If the executive order is not enjoined, local governments will face significant harm. Local governments are responsible for issuing birth certificates, which under the order will no longer automatically prove citizenship. Flip over here. The order would require local governments to either change the information provided on birth certificates or develop an entirely new process to verify citizenship. Additionally, I'm trying to keep everything straight here. Additionally, localities will bear a financial burden if the order takes effect. Currently, local governments receive federal funding for foster care expenses and health care for children who qualify for assistance. A non-citizen qualifies if they are a lawful permanent resident or have received one of the several forms of humanitarian relief, such as asylum or refugee status. People with only temporary legal status, such as student or work visas, or people without any legal status, are generally not considered qualified for these programs. If children born in the United States are not citizens upon birth, they will not be entitled to federal benefits, and local government will bear the financial burden for public services. These collateral consequences on local municipalities and taxpayers surely do not serve the public interest. The balance of equities and the public interest strongly weigh in favor of a preliminary injunction that maintains the status quo during litigation. All four factors weigh in favor of a preliminary injunction. Nationwide injunction. So this is going to be the judge's conclusion here. District courts have broad discretion to craft remedies based on the circumstances of a case, but likewise must ensure that a preliminary injunction is no more burdensome to the defendant than necessary to provide complete relief to the plaintiffs. So again, this is the legal test here. Indeed, a district court may issue a nationwide injunction so long as the court molds its decree to meet the exigencies of a particular case. And then we are quoting case law here. Here's our last page, everyone. Only a nationwide injunction will provide complete relief to the plaintiffs. ASAP has over 680,000 members who reside in all 50 U.S. states and several U.S. territories. ASAP expects that hundreds or even thousands of ASAP members will give birth to children in the United States over the coming weeks and months. Because ASAP's members reside in every state and hundreds of them expect to give birth soon, a nationwide injunction is the only way to provide complete relief to them. And then we're citing case law that gives the court that authority. Further, a nationwide injunction may be appropriate when the government relies on a categorical policy. The executive order is a categorical policy. A nationwide injunction against the categorical policy in the executive order is appropriate. It also is necessary because the policy concerns citizenship, a national concern that demands a uniform policy. Noting here out of the Arizona case that the federal government has constitutional power to establish a uniform rule of naturalization. And then we're quoting here Article 1. So the legislative rule. A nationwide injunction is appropriate and necessary. So here's our conclusion, everyone. For the foregoing reasons, the motion for a preliminary injunction is granted. The court enjoins the implementation and enforcement of the January 20th, 2025 Executive Order 14160, protecting the meaning and value of American citizenship. A separate order follows. And then it is signed February 5th by Judge Boardman. So there you have it. Let me go ahead and turn on comments so we can kind of do a bit of a Q&A here. Just to remind you, I did go through most of this case. We did skip a few pages, though, just in the interest of, I was going to say judicial economy, but that doesn't work here. So I will say, in the interest of time, that do it better. There we go. Oh, thank you so much. There we go. All right, we should be set. Hello, hello, everybody. Hello, hi. Hello, Jennifer. Hello, hello. Good to see you all. So I think this was a very, very well written order, very well, and it really sets up U.S. Supreme Court argument for sure. I thought it was great. And pretty much all of our cases are going to be that way. Oh, you bet, Nancy. Sure, sure. Hello, Mary. Hello, Deborah. Hello, hello, hello. Good to see you. Liz, hello. Good afternoon. Good afternoon. A fax raid, exactly. Exactly. Oh, of course. My pleasure, my pleasure. Glad you're reading those names. Oh, yeah. I think I did okay. I think sometimes, my pronunciation's a little different. Fax raid. What is the additional order? So this one goes through because the memorandum opinion and explains all of her justification, all the precedent. And then the order usually is just, 1 or 2 pages that just sets out now this injunction applies until, further notice. So, thank you so much. Yes, these were the nails, by the way, everyone who voted on my which nails should I wear post. These are the nails. Yes, good morning to you too, Bay Grandma. Oh, yeah. What are the potential that we can fight these executive orders? Very good, very good. A lot of these executive orders, everybody, and I'm kind of going through them again slowly. I've read through all of them at least once, but now I'm going back through them. And, this language, who wrote this stuff is what I keep saying. I'm like, who wrote this? Because, there are some things in there, sure, go for it. But other things like, no, that's not how that works. Oh my gosh, that is just not how that works. So I've been spending a lot of time going through that. And actually, I will be, puzzle piece, everyone, just one moment. I will be joining, I think I just reposted, I will be joining a couple of ladies on a panel on Saturday. And we're going to be talking about this. So we're going to be going through this very issue. And his AI bot, Rono, that's so funny. And his executive order. So the Birthright Citizenship order, those kinds of things. It's behind the slaughterhouse theory. Interesting. I'm not surprised. That John Eastman, he's something else. Just in case, always good to see you, by the way, Law of the Wild, thanks for joining. Just in case you've forgotten, this is Mr. Eastman right here. This is his mugshot out of Georgia for the RICO case. So, yes, not surprised. Yes, I feel bad. I think it's Swish. Is that right? I'll have to post it again, everybody. I'm just terrible with names. I feel bad about that. But 2 lovely ladies, and they've got some stuff going on. Child separation is very hard. Well, right, Jennifer. And, the other thing, too, is we're talking about infants. We're talking about a baby that's been born, right, and like a week later. That's not right. How can I help? How can I help the prosecution? Honestly, I think one of the absolutely most helpful things that anyone can do is to start to read and understand what's actually happening. So by just listening here to this, even if you want to pull this opinion up yourself and read through it, grab a couple of the cases that were mentioned in here, or just pull the statutes that were mentioned in here, that is incredibly helpful. I think if you understand how this is actually working, that's going to help so much. So I think that's the best way to do it. Swish, hello. Oh, there you are. Yes. I'm glad you're here. It's like, oh my gosh, did I say their names wrong? Oh, yes, I'm very excited about it. Oh my gosh, I'm really looking forward to it. Yes. Can't wait till Saturday. Absolutely. Yes, this will be posted to the Tube of You as well. So I've got a couple more here. I had to answer the phone. No worries. That was my bad. I was like, I'm pretty sure it's Swish. Oh my gosh. Oh my goodness. You taught me very much. Oh, I appreciate it. Oh, you're welcome. I'm glad to be able to help. And, again, everybody, for those of you that were also hanging out on Hawk's Live, Hawk and Falcon were on the Tube of You yesterday. So I try to not go live at the same time. I know I've got a lot of moderators crossing over, but, they were talking about AOC's Instagram stream, right? It's about 90 minutes. And it was amazing. She did great work because one of the most important things that I think can help everyone is to educate yourself on what's going on and really take control of that. Take control of your rights. Take control of what you know. And when you do that, it helps so much. So that was one thing that I just, you can't emphasize that enough. Just know your rights, know what's happening. And understand that, because that's the way to get your power back. She isn't. Oh, absolutely. Hope she'll post it on YouTube. Yeah, VC, it is actually posted there. You might have to look around. Yeah, that's a must watch. Absolutely. And it's not about here's our talking points. Sometimes I feel like leadership in both parties is like, here's our bullet point list, and we're just going to say the same words over and over again. What's so great, in my opinion, of AOC and Representative Crockett is that they are like, this is it, this is how it is, rather than just going through their list of, buzzwords. And I really appreciate that. I appreciate that so much. The broader perspective. Exactly. So, and one of the moments where I realized AOC was really so good for my own mental health was I heard her make a statement that said, we can't go back to the Obama Democrats time. We can't go back to that. And the other one too was that with the border, she's like, again, I'm quoting a bit of what she said, as the Democrats, we can't start to go Republicans just because we want to get something done. And that was kind of her stance on the border. And I was like, boom, sold. Take my money. Take my money. We love it. Oh, she does a great job. We need them. Also, I think there was a great interview with Bernie. A lot of people have been asking, Social Security, disability, Medicare, those kinds of things. And I always go and hunt Bernie down because he's got some really great pieces. And so he's got a couple of really interesting interviews that are up too on the Tube of You. You can check that out. Further to the left is where, I don't know exactly where they're headed, but I just I'm not sure that, riding coattails of, policies like that is necessarily a good idea, but that's just my opinion. So my opinion of the Kim case, really, the ARC, are you talking about the ARC case? Because I have posted things on the ARC case many times. So if anyone wants to look that up, you can write that name in and then just put in my handle, and you'll pull the cases up that I've already published on. Shouldn't be about Dems or Republicans. I agree. One thing too that I found very interesting, and I should probably do a post on this. There's been this discussion about how right now the strategy is to just flood everybody, right? So there's a flood of things happening. We've got executive orders, out the wazoo. I just printed the executive orders. I mean, look at this. These are executive orders, right? And so that's happening. And then we've got all kinds of other things going on with lawsuits and so forth. And the goal is, flood them and just flood the whole thing. And so that you're so overwhelmed that you can't catch up, and that, it's really overwhelming. And I kept thinking to myself, I'm like, what happens in the United States when a state gets flooded? Right? What is it that we as Americans do when, Louisiana or Tennessee or wherever gets flooded out, right? We come together and we help our neighbors. That's what we do during a flood. So I keep thinking to myself, I'm like, I don't know that this flood is really going to have the intended results that you're looking for, because those kinds of things are what pull us together. So hopefully we will be able to kind of work together to go forward how can you see the executive orders? The executive orders now are actually published in the Federal Register. So they are available there. I guess the first page doesn't say it here, but the Federal Register, or you can just put in this title here and it'll pull it up. Yep. It'll pull it up. Big boat with small rudder. Can't change directions quickly. That's so accurate. That's very accurate here. Oh my gosh. And we got to work together, but by working together, I'm not necessarily saying that we can work together with everyone, because that's just not true. There are some people that don't want to help when a place gets flooded. They just step to the side or go out and eat or get on a helicopter and go to a different state. There's lots in there. Grabbing onto the invasion claim. Well, we've got some questions about that, right? We've got some questions. And again, I think what's so great again about this order with this judge is she's just like, look, dude, this is history. This is what we're doing. And so for several of the things that I know Thomas is trying to go after, it's like, dude, this is history here. We got history. This one's Maryland, yes, but there is another one that was brought in Washington, and this one was actually decided before the Maryland case. So if you're interested in that, state of Washington issued that temporary restraining order. They were the first, and then we had another one here. Now, I think I saw someone say percent. Oh, yeah, there it is. Wow, it's like the moderators are reading my mind with the pinning here. I do not know the actual percentage, but I do know that there's a lot, everyone, even just myself looking through here, there's a lot. And I've not gone to the, what's it called? Is it called the Democracy Docket? I think, is that right? I can't, shame on me for not remembering, but there is a great website where they go through cases that are ongoing in states as well as federal. But just looking through several of these again, this stuff's unconstitutional. And depending on who's being affected, the ACLU is going to jump in here. We had the FBI Association jumping in here. There's a lot of groups involved. So it just is a matter of what the content is. And I think it's great because, again, with these cases, we've got AGs in states bringing cases, but we also have these not special interests, but these organizations, right? Like a union organization kind of thing, where they're coming in and saying, our people are being harmed. There hundreds of thousands of people are being harmed. So rather than it just be an AG, we have some oofta behind it. Federal Register, right? Thank you. Yep. This is Maryland. This that I was reading today is from Maryland. So right up here, we're in the District of Maryland. We've got two. While being contested, can they still put them in motion? So it's possible technically, but again, and what this judge was saying is, no. They're pausing everything. And that's one of the things that, I would gently remind everyone is that once something gets kicked into the legal system, it takes forever before anything gets done. So if you can bog down these executive orders in court, we're not doing anything that's not ethical. Just getting them into the legal system is going to take forever for anything to happen, as we have all learned. But it runs out the clock. And that's really what we're trying to do, everybody. That's like, oh, these are awful and this stuff sucks. If you don't feel that way, then, sorry. But if you do feel that way, we're running the clock out. And the best way, the most appropriate way is to get these issues into court because they pause it. Everything is going to be on pause. Thanks, Big Grandma. Yes, ignoring ICE. Right. You should, when you know your rights, then you've taken your power back, which is amazing. And when these cases, one by one, are going in, it's actually more than one. They're going in batches in the legal system. It slows everything down. Uses tactics against him? Yes. Or how I look at it is, now that everybody knows how slow the legal system is, like, there you go. Like, now, it takes a long time to get these cases through court. It takes a really long time, and even to get halfway up to the Supreme Court. So yeah, it's just a matter of, doing it. The other thing too that I'm hearing a ton of from my sources are that the phone calls are making a difference. And I don't know, what it is that you personally are calling about, but they're making a difference. They're definitely making a difference. Even if it's a voicemail, just the sheer quantity of it is speaking of flooding, is flooding Congress. So I think it's, full steam ahead, and it's absolutely making a huge difference. They grind slowly, absolutely, Swish. They grind incredibly slowly, but, like a tank, and, they grind over anything that they run up against. So, so that's important. Okay, yes. So again, yeah, the calls make a difference. And one of the things that I've talked about before is you don't have to just call your own representative and your own senator, right? You might think, well, I've only got a couple people here. Like, fine, that's fine. Or, only one person is in my area. That's fine. You don't have to just call your own people. You can look at the committees that are handling the laws or putting out the information. You call it the committee members, right? So, we've got the Judiciary Committee. That's important. Give them a call. Be like, and they're like, well, where are you from? Like, that's not important. What's important is you're on this committee. You hold a significant role in this situation. And just because they're not representing you doesn't mean that, you can't go and say, like, listen, Grassley, go and do something, man. So do that as well. Can circuit courts issue nationwide injunction? So there are going to be some issues, and it's not going to be particularly strong, but yes, it's possible. But, we're going to have some jurisdiction questions. What this judge was saying in this case was saying, what she was saying, a nationwide injunction may be appropriate when the government relies on a categorical policy. So we do have some cases here that support the ability to have a nationwide injunction. And she was saying this case affects 680,000 people and 50 states. So we need to go broad. I don't have the next thing, which would have been her 2-page follow-up order here. But yeah, it's a piece in there. Yep, for sure. So keep an eye on that, and I think that's important. Right. Bans federal funding to sanctuary cities. Yeah, oh my gosh. Vote in the midterms, right. Yeah, she's something different. We're doing this in conjunction with AC. Oh, absolutely, a thorn in everyone's side. Yes, exactly right. Well, and it just shows, too, everyone, when you make a call, you're shining a light. You're saying, I'm not ignoring this. I'm not going to just let this go. You become the squeaky wheel that gets, the grease or whatever, however that phrase is. Sorry, I was channeling my boomer mom, and I can't remember. Sorry, Mom. Anyway, but, that's one of the things. If you make some noise, people will look at it. And that's, I think, a really appropriate way to go. Point of going to be able to help. Well, it's all about jurisdiction. It's all about jurisdiction. And wherever the judges are, wherever things are filed, because I know we can have appeals going forward in all of these cases. And one of the things that, unfortunately, has been kind of a misnomer has been whichever president appoints the judges, that's, who those judges will follow, right? So that's if it's Biden, then all the judges will be like, yeah, go Biden. But technically, that's not actually true. That's a relatively rare situation when you have someone who was appointed by Mr. Trump and they're like, woohoo, we love Mr. Trump. So, I mean, that's relatively uncommon, really. But judges, brand new green judges, they make a lot of mistakes. They screw up a lot of things, but they also are ready to go. Like they're ready to do the work, and we love that. Okay, it is. Thanks, Joyce. Appreciate that. I appreciate that. I sometimes get my words tangled up a little bit. I love it. So I would say it's going to depend. And I wonder though, all the new judges though that Biden has put in, that was like a miracle, because now we don't have to wait for those positions to be filled, and they're already like hitting the ground running. And I think that's wonderful, especially because we're having so many issues with right, cough, cough, cabinet. Exactly. We're having some issues, right, with the FBI and the CIA. I mean, there's the DOJ. There's some stuff going on. So the fact that Biden was able to get judges like on the bench, I think it was huge. That's a huge win. And I'm not necessarily, I don't think any of us are saying, well, they're going to fall in line with Biden, but I still think that was a huge win. Old enough to know the phrase, oh, I love it. I love it. Oh my gosh, I need to like make a set of phrases that I need to use more frequently. So, oh my goodness gracious. I had this one, what's it? It's a dog. Is it dog eat dog world? And I used to say it all the time when I was a kid. I don't know why, because I was a dork. Like, well, it's a dog eat dog world. And I thought it was dog eat dog. So, like 15 years. And then I got into law school. I'm like, well, it's a dog eat dog world. Somebody was like, that's not actually right. I looked it up and I was like, oh dear. And I'm like in a full suit, heading to the Capitol. And I'm like, oh my gosh, it's dog eat dog. How have I lived my whole life calling it a dog eat dog world? Oh my gosh. It was a moment. You just have to remain, you have to humble yourself sometimes. You just do. We're not perfect. We all make mistakes. And it's okay to make a mistake. Then you go for it. I don't think anybody got hurt. So, oh my gosh. I know. Oh my goodness. A battleship. Oh my gosh. Oh, well, it means the same thing. Well, right. I mean, yeah. It's just, your ego in law school is just, it's fresh, right? It's growing, and then you just get knocked down repeatedly. So I'm like, whatever. I say it all the time. I think we should bring it back. That should be the proper way to say it. Oh my gosh, that's so funny. Well, that's right. I remember too, after my first moot court kind of argument. It wasn't moot court, it was for class, but I was rehearsing my closing arguments and I was like channeling all of the Tom Cruise moments. And so I was like, and another thing, and this is, whatever. And my professor walked by and he's like, you need to switch to decaf. I was like, but I'm doing this great closing. He's like, seriously, decaf. Oh my goodness gracious. Yes. So, none of us are perfect. We all, can take a moment to assess that you're not the greatest thing ever. All right, people. Need to acknowledge that. So with that wonderful moment in time, I will go ahead and sign off for now, everybody. Oh my gosh, it's so cold today. I agree. Thank you all for coming by and hanging out. We've got a pretty good idea now of what we're dealing with when it comes to the birthright citizenship issues. And we'll continue to go through this as time goes on. So when more cases get filed on these executive orders, I'll make sure to give you a heads up on that and kind of go through and explain it. Yes, and Saturday, Swish, I'm so excited about it. But I will be hanging out over there and we'll be talking about these big issues. So take care, have a great day, and good luck to you, and keep fighting the good fight, everybody.